Well, so first off, I'm assuming all you guys handle assignments from time to time,
Mhm.
right?
Sure.
We all do. And what I find so interesting is that these, we're just going to use the word wholesaler, okay? They all think that once they sign the assignment and the contract, they're still in control of the deal,
Oh, yeah.
and
Huh?
they don't know what they don't know, and they try to manhandle everybody. And I'll give you the scenario in this one instance. And oh gosh, a contract for sale scheduled to close, but it can't close because of title defect. And there's a provision in the contract to allow it to extend for 60 days. Got it. Well, there's an assignment of contract that assigned the deal to the back end buyer, but the assignment had a 30-day closing provision. Okay, I guess you can do that. That if it doesn't close in 30 days, the uh, the assignor has the right to terminate, so long as they do it in writing. Now, of course,
Mhm.
there aren't any notice provisions in the contract. And what I find so problematic about our industry is these, I'm going to call them kids, because most of the wholesalers out there are kids. And they think that by texting, that's going to be sufficient to do something. And they don't get it. And I know they're not lawyers, but it's frustrating. You think they'd listen and learn, but they don't. And again, 30 days out, it still couldn't close because of title issues.
Right.
And so finally, title gets cleared up. The buyer is unable to close for a day or two because of medical reasons. But at that point in time, guys, we've got a seller, we got a buyer, right? And this wholesaler who wants to play the game in the middle, he ain't part of the deal.
Mm-hmm.
And he tries to cancel the transaction, keep the buyer's earnest money, do this, do that. You kind of go, yeah, no, ain't going to happen. They're the only people who can set a closing date is the seller and the buyer. The wholesaler, the assignor, he can't set a closing date. He's not a party to the transaction anymore.
He
But
has
they
stepped
don't
out.
understand it. Yeah.
Yeah.
But they all, by the way, I get really frustrated with this, guys, because I deal a lot with this stuff, and these wholesalers, they just don't understand it. And of course, they run down outside and they file a memorandum of contract. Of course, they never have the intent to close. They don't have the ability to close. And all they want to do is tie up title to the property, right? And hold everybody hostage. And you want to slap them cross-eyed. So I could get more frustrated here if you want me to. But
no, and the thing is, I think it's a poorly drafted assignment. That's the main cause. I've seen situations where, it's just a unconditional assignment without reserving certain rights in favor of the assignor.
Yep.
And then the seller and the end buyer get together and decide, we're just going to cancel the whole thing. We're going to cancel it. And if it were just a straight blanket assignment, there's nothing that can be really done to stop that. So what are some drafting techniques on assignments and language that, can be put in there to make sure that things like that don't happen? What could be done on an assignment and some language to fix that?
And guys, before you answer that, if you're just watching the show, folks, you've joined the collective. This is a group of attorneys and professionals in the creative finance space that get together weekly to discuss creative finance and answer your questions. So if you have questions, post them in the chat. Right now, we're kind of dealing with Scott Horne at peak frustration level, dealing with folks who don't know what an assignment is and what that looks like on a wholesale type deal. So
and
Sean,
none of us deal with those issues, Andy. You know that. We don't deal with the frustration of these guys not having a clue what they're doing out there. They're just loaded cannons, just throwing whatever is out there and see what sticks. And then they want to, hold everybody hostage, charge more money, threaten people, and it's just like, what? Anyway.
We'll get to recorded memorandums in a minute. In fact, that was one of the topics I threw out there for Andy to talk about tonight. But let's talk about the assignments. What are some, some language, some different clauses that we can put in there? For example, in the assignment that I've put together, I basically, I want in my purchase contract to at least have a 10-day cure period, but then I put in the assignment that they assign certain rights, but it doesn't include the right to benefit from the cure period. And the minute that they don't close by the original close date, the, contract reverts to the original buyer and the assignment's void and of no force and effect. What are some other things that you've seen out there that works on assignments?
I got to think for a moment. I do think you try to teach. There's the wholesale world caught on fire, 3 or 4 years ago. And everybody is just exploded out there, and things didn't used to be there. They didn't used to do the memorandum of contracts really prior to 2008, 2009. And they came on the scene somewhere around 2014, 15, 16, something like that, and things of that nature. But, I try to teach the wholesalers. It's like, guys, if you want to stay in control of the deal, draft your assignment to a position that allows you to stay in control. That if there's a prescribed closing date and it does not close by a prescribed closing date, assuming title's clear, okay, then it terminates and reverts back to the assignor. That's a pretty easy one. What the contract in specific I'm talking about, this assignment, it stipulates a close date, but it doesn't stipulate a time frame like you were talking about, Sean, or things of that nature. It says close by the closed date, then it's a default. Well, the close date came and went 45 days ago and was extended by the contract. Nothing was ever terminated. But just because this thing didn't happen day one when the wholesaler wanted it to happen, they go ballistic. But they don't but if you want control of the deal, to stay involved, to stay with communication between the title company, seller, buyer, things of this nature, you've got to construct your document so it lays this out appropriately. And so often, I see these assignments and they may contain some of these items, but not all of them.
Right.
But, they want to manhandle the situation. They want to force people to surrender their earnest money and things of this nature just so they can capitalize on the situation. And they don't understand right is right and wrong is wrong. And I get wanting to get a deal done, getting the deal closed. But I sure wish the wholesale community would learn how to do that the right way and how to do good, proper business.
Well, I have been preaching to the wholesale community for several years, and only a few want to listen. So I'm going to unload on a couple of thoughts. And
is that why your forehead's so flat there?
That's why it's so shiny right now, because literally I'm doing this all day long. Yeah. All right. So first off, and Scott, I agree with everything you said, and you touched on some real interesting points, and I'm going to elaborate on it. Rule number 1, you can only assign a valid contract. If you're a wholesaler and you enter into a contract and you have no intention and no capacity to actually perform and purchase the property, I don't think it's a valid contract, and I don't think you can assign it.
I think you may have a failure consideration right there, right?
I think you have a lack of capacity and a lack of intent. You don't have a meeting of the minds. The seller, the homeowner's seller, thinks that this guy, the wholesaler, is going to buy because they responded to an ad that says, I buy houses, I close quickly, I pay cash.
Mm-hmm.
So, second point I'm going to make, and this is where I completely agree with all of you guys, is you have to be a mature enough investor mentally and emotionally to draft by design. This cannot be an accidental hobby where you grab free forms off the internet, don't read them, don't understand them, and just use them. And the last thing I'm going to say, because I could riff on this for a couple of hours because I've beat my head against the wall, and that's why I got this shiny flat spot there, is actually close on some deals. Because if all you do is assign your deals, I don't think you're legal. I don't think you're valid, except maybe possibly in Texas, because Texas has got a unique aspect of their real estate law that lets you do it as long as you disclose that you're just selling a contract. But anywhere else, I don't think you're valid. I don't think you're legitimate. And I think you're just doing stupid, wrong, bad. You need to be able to perform. And if you're really, really concerned about the expiration of that closing date on that contract, hey, guess what? Pull the assignment back, write it to where it doesn't happen. If they don't close on the day, the assignment's void, and then you step in and perform.
Correct.
Oh, but wait a second. That means they got to have money. That means they got to have the ability to perform. And that means that they have to do more than just dump this thing on an investor-friendly title company or title attorney and let them carry the load for them.
And by the way, they do that.
I know they do.
Quick little story. I go back a few years back and had an escrow officer who was heavily invested in the wholesale world. That all this stuff was coming in, and we had dealt with basic assignments with legitimate wholesalers who could close, legitimate investors. Oh no. And we had to change and put so many policies and procedures in effect regarding the wholesale marketplace. Because I got to a point where I said, we are not opening title at all until you have a valid assignment with someone who has the ability to close. Then we're open title for you. We're not going to waste our time, not going to waste our trouble. We're not going to go through all this stuff because it's just wasting our time. And you deal with a lot of these assignments out there come in, as you pointed out, with a lot of things where they all have, they just don't have hair on them. It's down their back and whatever it might be. It's front and back and arms and legs and everything. It's horrible. And half the time they can't even close. They're so problematic. But I think your points are dead on point. And
well, you and I are reading from the same playbook on this, because we've just had our fair share of dealing with, and I don't mean this pejoratively, except what I call knuckle dragger wholesalers, that they don't understand what they're really doing.
No,
they've watched a few videos on YouTube, they've watched some stuff on TikTok, and they think they're an investor.
Well,
I've thought one of the problems to this is sometimes the assignment and the form itself, in that you can effectively assign something in a half page. It doesn't take a lot to say, I assign all right, title, and interest to a thing to another party. So that gives the impression that, well, okay, the barrier to entry on these deals is pretty low, pretty easy for me to get involved in. And it makes, I think it makes what looks like an otherwise complex, or what is a complex transaction, as something simple. I can get this quick form, I can do it, and I've assigned it. And and the fact of the matter is, you don't even understand the assignment, and maybe you don't, like to some of Sean's earlier points. We talk about this a lot. You don't want to assign all rights and everything else. But I wonder if that's some of the cause, just that the forms look easy. A simple assignment form looks easy, and it looks like something we can just go run off and do.
Well, I hope y'all don't hold this against me, but I think the investor world is flat out lazy. They all want quick money, quick, easy. I heard it on the internet, therefore it has to be accurate. I pulled it down. And they don't even read the stuff. They don't even read the contract. It's like, what does the contract say? Well, I don't know. I didn't read it. Well, what is your assignment? Anyway, I'm sure we all deal with that. We all see it. I know the Texas marketplace is just, embedded with all that. And I'm sure Arizona is too. And it sounds like Ohio is as well.
Ohio has been a hot spot of it. And I have worked hard with the Ohio Division of Real Estate on what is the legal and illegal ways of wholesaling. And in fact, a video I created with the Ohio Division of Real Estate is now part of required continuing ed for all agents in the state of Ohio. And, we see this on a regular basis. That
here in Texas, they implemented in the statute a provision where you've got to specifically stipulate that you are assigning the contract between, and that they're not buying the property. You have to have that clause in your contract today. And of course, we all hear rumors out there that if you're going to be in that game, you hear the rumors of you have to be licensed in order to play that in some format. Hasn't
Illinois,
gotten here
you have
yet.
to be licensed. Oklahoma, you have to be licensed. Colorado, you have to be licensed. And there's more states coming. And it's because the realtor agent lobbying industry is sick and tired of untrained, unknowing, poorly prepared wholesalers going out and clogging the marketplace and making a mess. And one of the ways they make a mess, and I know we were going to talk about this, and so I'll throw it out there, and if we want to go there now, great. If we want to wait, fine, is going out and recording a memorandum of contract to cloud title when you don't have the ability to perform, but you're doing it because you're afraid somebody else is going to go around you. So you're all nervous and insecure, and you don't have the resources. You don't have a private money lender lined up. You don't have a hard money lender lined up. You don't have the ability to perform, but you're going to still go cloud their title.
Yep. I'll throw another point on there too. I'm sure we all see this. Is you made this point earlier, is that not only do they not have the ability to close the deal, which is probably 85% of the wholesale market or more, I would say, but they don't have a good contract, especially from a probate perspective. There's so much probate out there, and mom or dad passes away. There's 5 or 6 heirs. They get a signature, and they think they've got a good contract. They file the memo on that. They try to assign it, and it's like, yeah, timeout, can't do it. But they've tied up the property, and then they don't want to release it, and they want to hold everybody hostage and say, well, pay me a fee and I'll release it.
Well, there's actually, and I wouldn't even call them investors or wholesalers here in Arizona, where they actually they've made a business model of entering into purchase contracts for fair market value, or maybe even slightly over fair market value, with no intent to perform.
Oh yeah.
And they just record the memo, and they wait and they wait and they disappear and they wait. And then when you go to close, $5,000, $10,000, and that's their demand. And if you say no, they say, sue me. And they have an attorney that they always use. And
so, by the way,
there's the way it goes down.
There's a guru guy out in California. I don't know his name offhand right now. I've heard it several times, who teaches for $25,000 that exact scenario. And you hear that, you just kind of go, you got to be kidding me. But they do.
Right.
And he's just paying it out left and right and getting it. And then there's a company, I'm sure you guys have heard about it. I'm sure Alan may have heard about this, where they come in and they file a memorandum on the property where they have a 40-year right to sell the house.
Yeah, it's a real estate brokerage. It's a licensed brokerage. Yeah.
So I just locked horns with them. They had a bad contract, actually, so I got a little bit lucky. I showed them that their contract was bad, but they actually were fighting pretty good on this. But it's just, it's unconscionable. 40-year contract where if you go to sell your house, you have to use them as a real estate agent, and if you don't use them, you pay them 1-2% of the fair market value of the house, as dictated at the time of contracting. But when I saw it, I was like, dear God. And then I Googled it and saw that AG's office in several different states were suing them. Just horrible. Needs to be gotten rid of.
Yeah. The state AG's offices are winning. That business model is going to fold like a bad rug. It's going away.
Yeah, good.
Yeah. I know Texas has sued them as well, I believe. And it's easy, quick money people think is out there. No one's willing to put the effort into the business anymore. They all want that quick, fast buck, however they can get it, or they're going to hold you hostage.
I'm gonna really make somebody mad, and I'm just calling it like I see it. I've only been around the real estate investing space for about 20 years. So I got a lot to learn. Okay. I got a lot to learn. But I have noticed that there are a number of very high functioning drug addicts and alcoholics in the real estate investing space. They can't manage to keep a regular corporate business job, but because they're so high functioning and so smart, they can eke out a living as a real estate investor and sometimes do pretty good. But they don't want to read contracts. They don't want to do a bunch of stuff. They just want that easy money.
Well, and there's gurus out there similar to, teaching how to record memorandums, but there's gurus out there that are literally saying, hey, come pay me, a few grand or more, and I'll teach you how to, with $0 in your pocket, to become a real estate investor. Right. And so somebody who can't keep a regular 9-to-5 job is like, well, that sounds pretty good to me. And they go do that. And they find some contract, or the guru provides some contract that's, not been vetted and,
Yep.
An assignment, and off they go. And next thing you know, they, end up clouding title on a bunch of properties and not, finding assignees to close. And they just make a mess of it and create, a huge, dumpster fire at the end of the day.
Yep. So back in 2007 and 2008, when I created a whole contract methodology for short sales that rose to the attention of Freddie Mac, Fannie Mae, and members of Congress, that was an interesting day in my life. I designed documentation whereby you would record your notice of an option to purchase the property subject to the short sale approval. But I always drafted in the template that I made available an expiration date, that this option expires on this date. So that, yeah, you can go ahead and record it, but if you go read it, hey, it's not a valid option afterwards. The expiration day is passed. We can all look at a calendar. We can figure out what day it is. Oh, this thing expired on July 4th of 2023. Here we are on July 12th. It's no longer valid. But what somebody did is they came along, used my docs, took that out because they wanted to make it in perpetuity, because they figured this is a way to shake people down.
Oh, yeah.
Well, I'm glad to hear that we're all pretty much one mind on this stuff, because there is a lot of that's emblematic, that's ongoing in the marketplace, where it simply is a shakedown by these and again, I'm going to use the word, these young kids out there who think it's that easy, quick buck, as you made the point earlier up with. And that's just how they're going to do it, because they don't either have the time to learn the industry right, the time to go out and get the experience necessary, or the ability to have the capital or the hard money loan or their own resources to close that deal.
Yep.
So I get
folks,
it.
If you're just joining us, this is the Creative Finance Collective. And right now we're talking about individuals and investors that like to sink to their lowest common denominator, like much of mankind, I guess, whether they are, whether they're just lazy or whether they're on something. So the point of this is to kind of flesh through some of these issues and discuss it. We've been talking about assignments, and we've been most recently talking about memorandums, investors or quote unquote investors who just go lock up properties and record memorandums against the property wrongfully or without the intent to close, perform, or whatever. I think it's worthwhile going around, because we do represent a variety of different states, and maybe some of the folks, hopefully some of the folks that have sunk to their lowest common denominator and aren't doing it right are here watching and learning how to do it right. So why don't we kind of, at least from our different states' perspective, analyze or say when it's appropriate and when you can record a memorandum. Sean, you want to start with Arizona?
Yeah. So in Arizona, we do have a statute that addresses the wrongful recording of documents. And that statute basically states that any document that's recorded where there's no legal authority to record, or it's not authorized by statute, is going to be deemed a wrongfully recorded document. And the penalties for that is, if you knowingly record a wrongful document, it's $5,000 plus attorney's fees and costs. And if there's actual damages, then it's treble the actual damages, if that is greater than the $5,000 in statutory damages. And so that's been interpreted to mean, if your contract does not give written permission to the buyer to record a memorandum, then, any memorandum is going to be deemed wrongful. Now, like Texas, we have statutes in place that allow basically for wholesaling, as long as, similar to Texas, you disclose in that contract that you're a quote unquote wholesale buyer who intends to assign the contract and not close on it yourself. And if you do that, then you can enter into a valid contract as a potential assignor of that contract. And it would be deemed valid. So basically, my position here in Arizona is, if you enter into a purchase, you as a wholesaler can enter into a purchase contract with the intent to assign. And if you have in the contract that you have the right to record a memorandum, then you have the right to record the memorandum. Now, if you don't close and that memorandum stays a record, you have a duty by statute to release that memorandum, or there's damages for that. So that's also important to know. Like, you can record it, but the minute, you don't perform and that contract is no more, if you don't have a cure notice and you have an escrow date and you don't perform by that escrow date, I don't care if there was a title problem or whatnot. If you didn't get it extended properly, you didn't get it extended properly. And at that point, unless you have language saying it automatically extends or you can give notice of it, that type of thing. But otherwise, if you have a date certain, closing, you're supposed to close by that date. And if you don't, you should release your memorandum.
What's it look like in Ohio, Jeff? Is there ever a circumstance where you can record a memorandum there?
Yeah, there are circumstances where you can record a memorandum. And my response is that we look at it under the proceeding, what we would call slander of title. So if you record a memorandum and you are unwilling, don't have the capacity or the intent to perform, you have now slandered their title. You have got to be able to specifically perform in order to validly go record a memorandum. Otherwise, you've broken the law. There's a civil action they can bring against you and probably recover attorney's fees. And if you're dealing with a homeowner, you put their property under contract, now you've also probably tripped over some consumer protection statutes, and the Attorney General's office can come at you, and you're also looking at some treble damages issues.
Sounds pretty similar. What's Texas look like?
So we have a fraudulent recorded document statute, 12002 property code, I think. And it's similar to what Sean was saying, $10,000 statutory fine, attorney's fees, or actual damages if you file a fraudulent document. And it's ex parte review by the court, and we've used it several times. Courts are confused by it. I don't know when the statute came into play, but we're having to explain to the courts, hey, this is what the statute is, and here's how it works. There's that. We don't have any regulations. If you're going to be wholesaling, you have to give the material terms of the contract and state that you're selling you equitable interest. But outside of that, we don't have anything. I'll let Scott join in if I've forgotten some of the stuff we have here in Texas.
But Alan, that comes from our old days of the Republic of Texas.
That's right.
Out there.
That's right. We
And y'all
piggybacked on that.
Don't hold me to this one, but I had a roofer one time who was the sheriff of the Republic of Texas, who had his own silver coins. I still have one of those somewhere. And of course, he invited me out to their inauguration somewhere out in the woods around Athens for the opening of the capital of the Republic of Texas. And guys, did y'all ever see that old movie called Dragnet?
Yeah.
That had what's Dan Aykroyd was in it. Anyway, and they go out to some event with all this stuff going on. It's maybe a KKK type event thing, and he's in these bushy chaps that look like some I don't know, mythological scenario, but that was the vision going through my head when I went, yeah, no, we're not going to go out there, but thank you for the invite very much. But as Alan said, that you find people out there who do file these fraudulent documents out there. They don't even know that they can't do that. And one of the things that I do, guys, is I don't actually file a memorandum. I mean, what is a memorandum? Okay, there's a contract out here. Great. That's all it says typically. It doesn't lay out any facts. They don't record the contract. They don't put anything else out there. And so we try to avoid that at all costs, filing those. I think it's an improper practice. But if I do an affidavit of the contract that stipulates, the buyer. Here's a copy of the contract so you can see it and the close date, actually who the closing agent is, and things of that nature. So you have something that you can relate to. Because how does anyone really know that there is a contract out there, supposedly? It lays out that the buyer is ready and willing to close, just like Jeff said, that you have the ability to take the deal down, actually, as opposed to just assigning the contract. And you do that when the seller is refusing to close the transaction, obviously, because maybe they have gotten that better offer from somebody else, or they've made the decision just not to move. And I know we all see all those kind of excuses out there constantly. And I've actually seen a few title companies here in Texas close around the memos. Maybe they know that the contract is invalid for multiple various reasons out there, or whatever it might be. And they just go, yeah, this is an invalid contract. We're not going to let it hold up. Maybe just go ahead and close it. Now, of course, when we do that, that's not necessarily up to us boys to make that call. That's up to the underwriter. But sometimes we can guide that underwriter around by the nose properly and demonstrate why it should go ahead and close the deal.
So in Arizona, I'd be curious. In Arizona, traditionally, and this is probably the same in Texas and Ohio, traditionally, you don't record memorandums when you do real estate transactions. If you have a property listed for sale with a licensee, you just, enter into a contract and you close escrow, and, there's never a need for memos. And of course, that plays into the idea of, in Arizona, we're a race notice state. So it doesn't matter if I have a recorded memo or not. If a subsequent buyer comes in after me and tries to undercut me, and they know about my contract, they take it subject to my contract. We've had some cases where that happened, and our client, could perform and was intending to perform, and they didn't have a recorded memo. And they just called up the seller on a recorded, call and said, hey, I see you ended up closing, to what looks like to be an investor. What did they say when you told them about my contract? Oh, well, they told me, don't worry about it. Blah, 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 blah. Bingo, list pendants, lawsuit, title claim, the whole thing, right? Now you're on the hook. Are you guys kind of the same way, race notice, states where you can do something similar to that, even if you don't have a recorded memo?
I think one of the things that you run into because what has happened, at least in the Texas marketplace that I've seen out there, is wholesaler 1 goes out and puts the house under contract at 10 o'clock in the morning. At noon, wholesaler 2 shows up. The seller goes, oh, I've already signed the contract. And of course, wholesaler 2 goes, oh, we can beat it and pay you more money. And of course, we have unsophisticated sellers in those scenarios. They don't know they can't do that. Now, the investor knows they can't do it. And then, of course, at 2 o'clock, someone else comes out and signs another one, just escalating the price along the way. And I think one of the issues that these wholesalers who do that run into, and they don't think about it, is they're interfering in contract as well. If that
Yeah,
first contract out there to
right.
be actionable. But the biggest problem is with all of this is these wholesalers have no money. They're going under contract in an LLC that has no assets. And, the question becomes, is it worth paying the money versus filing the suit? Or is there another way to get around that without having to deal with these guys?
Well, if they
And
still own the property, then it's worth it, right? If depending on, if they bought it subject to and there's no equity or whatever, maybe it's not worth it. I don't know. But if they've, found an in buyer that closed on it and they own it free and clear, or they even, then it's probably worth it. If they went and got a hard money loan or a loan to buy it, then you're kind of hosed because you would have to show that the lender had knowledge of the prior deal, and that would be hard. But
yeah, I just think the overall process, I don't know where these things came from or who came up with them. I understand why they came from, but I wish the industry would learn how to properly utilize them, or a proper document to verify and validate things of that nature. But no one does, because it's all the drive for that quick buck that all these guys are looking at out there.
Well,
And it's gotten real problematic.
The common theme from everybody, regardless of the device or the document you choose to record, whether, like Scott mentioned, you like an affidavit, or whether it's a memorandum, there are investors that are wanting to use that and utilize that device to lock up a property. And the common theme appears to be, given the states that at least we're representing here today, is that it can be done if there's consent and authorization given by the property owner in order to do that. So transactionally, how do all of you like to set that up, or give the investor that authorization and authority to do that? Do you like to add that as part of the purchase contract or somewhere else? How do you like to go about doing that?
We're not hearing a lot of volunteers.
I don't think seller needs to authorize the filing. I think the filing of notice to the world that there's an existing contract is fine, enforceable. I agree with everyone saying that the way that it's being used now is not fine. But I think if you give notice to the world, affidavit, memorandum, what have you, that you have a contract to purchase this property, that's fully enforceable and defensible, until the cows come home. But again, I agree. The way it's being used now, it's a gross distortion of what is allowed by law.
in Arizona, it would violate our statutes to without authorization, because ARS 33420 here in Arizona, I think it's subsection C, I want to say, but it basically states that you have two options to be able to record something against someone's property. One, it has to be authorized by statute. Well, our statutes are very clear that there can be no document recorded which is not acknowledged by the party to be charged, or the owner of the property. So unless they acknowledge it before a notary, so the purchase contract would have to be notarized. Unless they acknowledge it before a notary, you cannot record by statute. So statute is off the hook. So now is it authorized by law? That's where having that provision in the contract. If you don't have that provision in the contract, then it's not authorized by law, because nobody gave you authority to record a memorandum against the property. So by statute in Arizona, now case law, common law, slander of title stuff, I think you're right, Alan. But here in Arizona, as far as our statutes go, it says that a document that's recorded without one of those two things existing is going to be deemed, wrongfully recorded.
So Texas law says there's a finite number of liens you can file against a person's homestead. But I've heard that we don't call the memorandum of contract or the affidavit of contract, we don't call it a lien.
Right.
We call it notice to the world. So I don't think our statute would seep over to an MOC. But I don't know.
Well, I agree with you, and with all of that, in that a memorandum of contract is just that. It's a memorandum. Hey, there's a contract. It is not a lien on property. And, most of this deal, mostly with homesteads that are selling in most instances. And as Alan said, there's only a few kind of liens that can attach to a homestead, at least here in Texas, thank goodness. But everybody thinks that this memorandum creates a lien on the property, and it doesn't. It creates just a cloud, maybe. And that cloud can be insured around and closed around. And if the seller elects to close around that memorandum of contract, then I think what you wind up with is a breach of contract, maybe. I don't know if would a title company per se have liability for closing around a memorandum of contract that's out there when it is not a lien on the property. It's kind of like, here in Texas, we're seeing more and more and more of these solar panel liens that come up, which are they're UCC liens that get filed, but they only attach to the personal property, but they record them in deed records. And now, of course, the title companies want us to remove these from, the record. And that's a whole nother conversation we could have about that and how to handle that and how to navigate that. And that's getting to be more and more and more, problematic in the marketplace because they're selling more of these things everywhere. And they will, the UCC company or the company that holds the banking entity that holds that, you can't even get a hold of these guys.
I think the title company has major exposure for closing around a memorandum if in fact the contract is still valid and enforceable. If there's a valid and enforceable contract out there and the title company is aware of it and closes over, I think they have huge exposure. One of the more interesting cases I had, this was years ago, was our client bought a piece of property or a home, and the title company was researching or getting there was a private loan against it. So they were calling another title company who they knew somebody there to get a loan payoff. They were calling their servicing department. So they called their friend and said, hey, we're looking for this payoff. And, can you send it our way? And they said, oh, really? This property? That's interesting. We have an open escrow on that. Oh, really? And they said, but I don't think the buyer performed. So, it should be fine. And that was the end of the conversation. Long story short, my client buys it. They close. Nobody disclosed it to him that there's this other escrow out there. And the, other buyer comes out of the woodwork, files a lawsuit. And this thing, years of litigation and, claims involving the title company and title insurance. I mean, and the title company, to their credit, they finally took care of it, but it wasn't cheap. And, they knew about it. And of course, by law here in Arizona, the knowledge of a title company is imputed upon their principal. So if an agent is aware of something, it's like the principal knows of it. And so it was imputed on my client as the buyer that he knew of a existing contract, even though he didn't, he had no clue. And it was a major mess. And yeah, I think a title company has major exposure if they see a memorandum out there and they close on top of it. If it turns out that contract's valid.
We had one in Dallas, title office closed on it. MOC was there. Our guy was a very principled Northeastern individual. So he was mad and decided to spend money.
Is that a polite way to say a Yankee or what?
It is these days. You gotta be correct. You gotta be political. And so he went after the agency and well, strike that. Went after the end buyer. End buyer was innocent. End buyer filed a claim, and so they ended up paying $15,000 plus attorney's fees to fix the issue.
Wow. Well,
I just find it.
Go ahead, Scott.
I just think I find it interesting too. When you ask these guys to produce a copy of their contract, they won't do it.
Mm-hmm.
Well, we've got it. It's at the title company. Well, what's the title company? You know, what's their contact info? And half the time they won't produce it for you for various reasons as well. But anyway, I don't know who came up with memorandums like this in this instance and this proliferation of them. I wish they hadn't, though.
Well, if you're just joining us, everybody, this is the Creative Finance Collective, where we have professionals from all over the country that have joined us here today to talk about creative finance and the laws pertaining to it. We've had a lively discussion about assignments and about recording memorandums. We do have a question from the audience, so this might be somewhat of a shift here in topic a little bit, but we can come back to any of this if anybody feels further strongly about recorded memorandums. But here's the question from one of our listeners. If the deal doesn't close by the close of escrow date, is it no longer enforceable? Question. What if it says on or about the date of close of escrow? So is the agreement no longer enforceable if it fails to close by the close of escrow? And I think that's going to depend largely on the purchase agreement itself, but I'll throw that to you guys.
Well, the first question that goes through my mind is, why can't it close by that date? Is there a title flaw? Are we, what's going on? Somebody out of the country? What's happening? And because that's going to matter, that, and then the fact, taking that effect and interpreting it against the purchase and sales agreement is where you're going to find your answer. I mean, I would say that in this scenario where the buyer is ready, willing, and able to perform, they've wired their money to the title company, and then closing date shows up, close of escrow is supposed to be on, July 13th, 5 o'clock on the 13th rolls around and the seller says, I ain't coming in, I ain't signing. Is it still a valid contract? Yeah, it's still enforceable. Right. And my buyer has the right to go sue for specific performance. But if it's a situation of where the contract says that the seller is going to deliver marketable, insurable title, and all of a sudden the seller who signed the contract only owns an undivided 1/2 interest in the property, that's a whole different animal. That's a whole different reason. And I don't know if that's a valid enforceable contract or not. You may be able to close and buy an undivided 1/2 interest and then sue for partition later on, but a lot of investors don't want to think about doing that.
So, by the way, I love what you just said, because sometimes we do a lot of that, just that format, because these guys don't understand that if they only have one of the two heirs, the heir can't obviously sell all the property at the full price of the contract. But can you hold that one heir their feet to the fire to sell their half interest for the portion that they would be receiving? And the answer is pretty much so. You won't be closing that in a title office, obviously. But could you force that heir to close? You could. And then, of course, from there, you can go with the partition route if that was available and things of that nature too. But most of the people in the industry don't understand that, don't want to go through with that, don't have the capital to do it. All sorts of issues like that arise.
Yeah, I'm sorry. I firmly believe that real estate investing is a thinking person's business, not a run and gun show. Not a shoot from the hip and figure it out later show. I mean, to me, you make money by thinking. You draft by design, you structure on purpose. I was telling somebody today that I've gotten to the point now with the deals that I personally do. I'm designing the deal that I'm ready to do to open the door for the next 2 deals down the road. And they looked at me like, what are you talking about? I'm like,
well, Jeff, you're playing 4D chess. I don't think the average
Well,
investor is not there yet.
but they can get there. They
Yeah.
can get there. They gotta stop and think. I mean, you just gotta stop and say, okay, what's my purpose for buying this property? And then go from there. Because anything I've got, I'm willing to trade it into a bigger, better deal. So
Yeah, but
anyway.
these guys' thought processes stop at the end of their nose most of the time. That they find a deal, maybe they're fortunate to get it under contract, and that's it. Then it's like, oh, what do I do now?
Yep. So I'm going to jump at the follow-up question that came on this. It seems the lender did not provide the seller all of the documents needed. Was there a financing contingency in the contract? Because the financing contingency would control here. If it's a lender issue and you're making the contract contingent upon the lender being able, then you probably need to have a conversation about extending it out.
Yeah.
Leave it there.
Well, yeah. And I agree with your analysis, Jeff. I think, if the buyer can show that they were ready, willing, and able to buy, they've wired the money, they're ready to go. And even if maybe it's a title issue holding it up and they simply can't close because the seller's not performing, even if that means that, they're not clearing title or in a lender, if they're not getting a payoff or whatever, I think it's still a valid and enforceable contract, but the buyer needs to be ready to go. The buyer can't just sit there and be like, well, it's a title issue, so I'm not going to, show that I can perform and put the money in and be like, all right, I'm ready to sign. We've had cases like that where, there was no cure notice in the contract and we had a hard escrow date, and the seller's now ghosting the client, and it's a few days before escrow. And, it's like, okay, you talk to that title company, you send an email and you say, what are my wiring instructions? What documents do I need to sign? I'm ready, willing, and able to sign right now. I'm ready to close. And you get that in to, prove up and establish that contract. But I do want to address the on or about language that was in the section. For contract drafting purposes, that is not a thing. Take that out of all of your contracts, because that should not be in there. Now you can have on or before language and say, we're going to close on or before, but on or about, no, like that's vague, ambiguous. That should never be in anybody's,
how does that match up with time is of the essence? How do those two things in the same contract get along with each other?
Yeah, exactly. So, and then my last point is to both your and Scott's point, as far as partition, I've had some clients who have made a lot of money buying, separate interests, percentage interests in real estate, and then going and partitioning. Normally it's, you have one sibling who inherits mom and dad's property, who's been living there for their entire life, adult life, not paying rent. They're happy as they can be, just living there and not paying rent. And the other siblings want them out and want it sold, but they don't want to be the ones to evict, right? They don't want to sue their sibling. Right. And so they don't want to deal with it. So they're willing to unload their interests and then let the investor be the bad guy. So partition's a real thing. And if you ever are presented with the opportunity to buy a partial interest, I wouldn't shy away from it. I think, if the price is right, by all means.
Well, I got to tell you guys a fun story, if I can tell you a story about a partition. So, had a house that was going up for tax foreclosure here in the DFW area. And the daughter of mom and dad lived in the house. As you said earlier, been living there for free for like 8 years. There's 40,000 or more behind in property taxes, and it's going up for foreclosure. And so obviously no probate was ever filed on mom and dad. So as you find this, you meet with people, you have to go through and start putting the pieces together, of course. So you put them together, and we find that dad had 6 kids by a prior marriage, and mom and dad had 2. And of course, nobody talked to anybody for the last 8 years. And it's just like, you got to be kidding me. And you see more and more of that out there in the industry, it seems like. But we went ahead and bought this young lady's, I want to say it's probably a 30% interest in the property along the way. We stopped the foreclosure. We got a deed from her for just a couple $1,000. And then we had to go find the other heirs. And we track this one lady down in New Orleans. And oh my gosh, I was the devil incarnate because I was stealing mom and dad's house. Even though they had dealt with mom and dad for the last 8 or 10 or 12 years, and this one lady in the house had taken care of them through all their illnesses and whatnot. And I mean, they wouldn't even talk to me. So I had to get my litigation attorney involved. And he was able to talk to this one lady, and they actually got a lawyer. We talked to their lawyer out in Louisiana and got it resolved. So of the 6 kids, we got 5 of the 6 deeds from them fairly easily, and paid them a fair profit for it. But we're still missing the daughter that has 30% and one other heir on the son on the dad's behalf. So somehow through Facebook, and guys, we couldn't have done this 20 years ago. We find that this one daughter lives somewhere in New Orleans, and she works for a hotel as we think she's a manicurist or something in the spa. We don't know. And I'm just going, this is not worth it going and trying to hunt her down. Let's just file our partition and move on. But my partner gets $43 round trip tickets to New Orleans from Dallas. And that is cheap. I'm sorry. And I said, okay, for $43, we'll go to New Orleans and we'll do that. So we fly to New Orleans, get a car, and we go to the house where we think she might live. There's an AC running, but no one will come to the door. So I walk next door to the sixplex, and all these doors are open. So as I'm walking up the doors, I'm just going to ask the neighbors if they know this person or not. Every door starts to close. Not one person will talk to me. And so you start going, oh my gosh, I am the wrong guy in the wrong place in the wrong part of town. This is coming up real quick. So we go downtown, and literally we go to every hotel in downtown New Orleans. I pull up, my partner runs in, runs out, asking if she works there or not. We cannot find her. So along the way, at least we have a good lunch in New Orleans. We go put a nice handwritten note on the door, and we go to the casino because our flight flew in at 6 o'clock in the morning, and we don't leave until midnight. That was the price of $43. So while we're sitting there, playing craps, we get a phone call, and it's this heir, and she's the concierge at the Hyatt Regency. And so we go to the Hyatt Regency, this cute gal, she's smart. And of course, she's the one who took care of mom and dad and paid for everything. She winds up being the only one who actually had a job in the family, which is why no one liked her. So we got 97% ownership right there. And the brother lived in Baton Rouge, and we actually found him, drove to Baton Rouge, and this guy would not talk to us. I mean, there were something going on. We think he was on Section 8 in this complex where he lived and whatnot. And from the neck up, he was short a few screws, we think. So we still had to go through our partition along the way, but we at least controlled, 97% or so, whatever that number was, of the property. It was substantial, maybe 93%. And so that at the end of the partition, we only had to put 7% of the net proceeds into the court registry for this one brother. So every once in a while, you can get a fun deal that works out right if you're willing to go the distance to do things like that. And it wound up being a home run deal. And it's kind of fun to talk about, but most people just aren't willing to go that far in these kind of transactions.
You mean I can't do my real estate investing from my computer at home? You mean I actually got to go talk to people?
And you can't text everybody.
Oh, yeah. Okay. I'm not gonna belabor my sarcasm anymore.
Well,
yeah, I don't know how you could possibly do that deal without social media now. Be able to find those out, but that is super interesting. See, if you're not watching the show, you're missing Campfire Stories with Uncle Scott. This is good stuff you don't want to miss. So, guys, we're coming up here in about 30 seconds at the end of the hour. So we won't belabor it any longer. We appreciate everybody coming on. Make sure to join us every week. to find out what to do, what not to do, and what people are doing in creative finance. Guys, appreciate y'all being on. Look forward to seeing you guys again.
Thanks, everyone.
Good seeing everybody, guys.
Yep.
Thanks,
I'll be
guys.
on an airplane. I'll be on an airplane next week, so I won't be on. But sorry,
No.
Southwest will not let me do video streaming from 37,000 feet. They just have a rule against it.
Oh man. Well, we'll see you when you can get back, everybody. Thanks again. Talk to you soon.
You guys have a great day. Bye, y'all.
Thanks, guys.